Hi, I'm Claire, and today I'll be briefly explaining the unjustified threats provision under the Patents Act. IP litigation generally is known to be extraordinarily expensive and often out of reach of litigants. It's tempting for a patentee to threaten alleged infringers with legal action in an effort to ward off expensive and time-consuming litigation. The right a patentee has to take legal action against an infringer is the foundation that gives a granted patent its strength. However, caution should be taken when exercising this right. By threatening a perceived infringer with legal action may result in the alleged infringer claiming an unjustified threat. In this scenario, Ben has been granted a patent and becomes aware that Frank is infringing on his rights. He corresponds to Frank on his alleged patent infringement. Now, under Section 128 of the Act, an aggrieved person, in this case Frank, may seek relief from unjustified threats of infringement proceedings. Per Section 128(1), Frank can seek relief from this threat in several ways. Firstly, a declaration that the threats are unjustifiable, an injunction against the continuance of the threats, and the recovery of any damages sustained as a result of the threats. Now, we'll briefly explore the unjustified threats provisions elements listed out here. Element 1, delivery. This element contemplates circumstances which a patent holder seeks to inhibit competitors by making vague threats by means of circulars, advertisements, or otherwise, as well as by more conventional means, such as letters. This element has been interpreted broadly, capturing almost any means to deliver a prospective threat, including threats made orally, in writing, by means of advertisements in newspapers, trade journals, or including as a circular with packaging of a product itself. Element 2, threatens. In order to be actionable, the communication must specifically constitute a threat of infringement proceedings. So the question then becomes, what constitutes a threat? For patent cases in Australia, the most commonly accepted test for determining whether the communication constitutes a threat is whether the language would convey any reasonable person that the author intended to bring proceedings for infringement. The second question then becomes of this element, when is a threat unjustified? So we'll explore this by looking at two cases, Mizzy and then DSI. In the case of Mizzy, Mizzy was the owner of a patent for cane billet planter, a planting apparatus for sugarcane. Mizzy initiated proceedings against Morellini for infringement of the patent. Morellini counterclaimed that the patent was invalid and unjustifiable threats. The basis for Morellini's unjustified threat was a generic and vague threat which appeared in the Cane Growers magazine, where Mizzy had placed an advertisement including a patent application next to an article entitled Infringement Danger. The author of that article had worked with Mizzy on the patent application. Morellini's counterclaim for patent invalidity was unsuccessful, as the court found Mizzy's patent to be valid. The court also held that Morellini had not infringed on Mizzy's valid patent. However, although the threats were not directed at Morellini, the court found that the advertisement alongside the patent application was an unjustifiable threat. The 2013 case of DSI and Garford contemplated a threat by Garford to sue DSI for patent infringement of a patent for rock bolts held by DSI. The court found the claims to the product lacked inventiveness and were held invalid. As the court held that the patent claims were not valid, there could be no infringement and therefore considered the threat by DSI to Garford unjustified. So then when is a threat justified? Well, per Section 129 and the case of N&E Bowder, threats of infringement proceedings are considered justified where the claims in question are valid in the eyes of the court and are actually infringed. Thanks for watching.